Lujan versus the Defenders of Wildlife, 1992. Court. This case was decided by the U.S. Supreme Court in 1992. Issue. The issue here was whether a party has standing to litigate a generalized issue against the government in federal court, even if she has not suffered a personal injury other than that suffered by all citizens. Facts. The facts of this case are as follows. Section 7A2 of the Endangered Species Act of 1973, aka the ESA, or the Act, requires federal agencies to consult with the Secretary of the Interior or the Secretary of Commerce before undertaking actions that might jeopardize endangered or threatened animals. The ESA also provides that any person may initiate civil suit on her own behalf to enjoin anyone, including the government, from violating the Act. Importantly, in 1978, the regulation on this matter extended to federal actions in foreign nations, but by 1986, the regulation limited the geographic scope of the Act to the United States and the high seas. Lujan, the Secretary of the Interior, was sued by the Defenders of Wildlife, who sought a declaratory judgment that the interpretation of the new regulation was wrong. They also sought an injunction so that the older interpretation of geographic scope would be restored. The defenders argued that they were injured because the lack of consultation for government entities acting abroad increased the rate of the extinction of various species. Lujan moved to dismiss the suit for lack of standing, and the district court granted his motion. The Court of Appeals, however, reversed that decision and remanded the case. The district court then granted the defenders' motion for summary judgment and issued an injunction. Lujan appealed that decision, but it was affirmed by the Court of Appeals. There was a lot of back and forth until the case finally wound up in front of the U.S. Supreme Court, which had to determine whether the plaintiffs in this case actually had standing. The court decided they did not. According to the court, the defenders could not litigate the matter because it was a generalized complaint against the government based on harm suffered equally by all. Standing under Article 3 has three elements. 1. The plaintiff must have suffered actual injury. That is, an invasion of a legally protected interest, which is A. concrete and particularized, and B. actual or imminent. 2. The plaintiff must show a causal link between the harm and the conduct at issue that is fairly traceable to the challenged action and not the result of independent action of some third party. And 3. It must be probable that a favorable verdict will redress the harm. Furthermore, the court stipulated that the burden is on the plaintiff to demonstrate these elements. However, the court concluded that the defenders failed to show any actual harm. Their allegations were too speculative, and they failed to show how a favorable verdict would redress an injury. Moreover, there was no procedural injury suffered to bring suit under the citizen suit provision of the Act. Holding. The court held that there was no standing and reversed the decision of the lower court. Rule to remember. Under Article 3, a party does not have standing to litigate a generalized grievance against the government in federal court if they suffered no personal injury other than the harm suffered by every other citizen.